myself Salim Khan, I'm professor at Law College, Noida. Today, I'm going to discuss with you the Sociological Schools of Jurisprudence. And this is one of the most important schools of jurisprudence. So, what is Sociological Schools of Jurisprudence? Sociological Schools of Jurisprudence, the main characteristics of the Sociological Schools of Jurisprudence are, first one, according to these schools, law is not unique, but only one of the social control norms. Next one, the socio-economic problem of the present time cannot be solved by means of the existing laws. Next one, laws in the books and institutes containing formal views, legislations, and expositions of particular subjects is not where the real law in society is to be found. Next one, law is not an absolute and static body of rules in themselves, but are relative to time, place, and society. There is a concept of justice in the sociological schools of jurisprudence. There are some eminent jurists in which first one is Montesquieu. Montesquieu was the French philosopher and he paved the way of the sociological schools of jurisprudence. He was of the view that the legal process is somehow influenced by the social conditions of society. He also recognized the importance of history as a means for understanding the structure of society and explained the importance of studying the history of society before formulating the law for the society. Montesquieu, in his book, The Spirit of Laws, wrote, law should be determined by the characteristics of a nation so that they should be in relation to the climate of each country, to the equality of each soul, to its situation and extent, to the principles of occupations of the natives, whether the huntsman or shepherd, they should have a relation to the degree of liberty which the constitutions will bear, to the relations of the inhabitants, to their inclinations, riches, numbers, commerce, manners, and customs. The next jurist of sociological schools of jurisprudence is Juvenile. Juvenile was considered as the founder of the sociological schools of law. Sociological schools of law is the study of law from the sociological perspective. English considers society as a main source of the law, and by society he means association of. English had written that center of gravity of all legal developments is not in legislations or judicial decisions, but in society itself. He argued that society is the main source of law and better source of law than legislation or judicial decisions. In this series, the next jurist is Dean Roscoe Pound. Dean Roscoe Pound was an American legal scholar. His view is that law should be studied in its actual working and not as it stands in the book. Dean Roscoe Pound propounded the theory of social engineering. Roscoe Pound views the theory of social engineering in which he compared lawyers with the engineers. Engineers are required to use their engineering skill to manufacture new products. Similarly, social engineering are required to build that type of structure in the society which provides maximum happiness and minimum friction. According to Pound, law is a social engineering, which means a balance between the competing interests in society in which applied science is used for resolving individual and social problems. Social engineering is the balancing the conflicting interest of the individual and the state with the help of law. Law is a body of knowledge. With the help of law, the large part of social engineering is carried on. Law is used to solve the conflicting interest and problems in the society. According to Dean Raskopound, everybody has its own individual interest and considered it is supreme over all other interests. The objective of the law is to create a balance between the interests of the people. For example, Article 19 of the Indian Constitution provides a right to speech and expression. But on the other side, state put some restrictions on this right. And when the conflict arises between the individual rights and state's restrictions, then the law comes to its part and solve the conflict between the interest. Raskopound, in his interest theory, mentioned the three kinds of interest. To avoid the overlapping of the interest, he put boundaries and divide the kinds of interest. First one, individual interest. Second one, public interest. Third one, social interest. Now, first one, individual interest. There are claims or demands involved from the standpoint of the individual life, which consists of interest of the personality, interest in domestic relations, and interest of substance. Second one, public interest. These are the claims or desires asserted by the individual from the standpoint of political life, which means every individual in a society has a responsibility towards each other and to make the use of things which are open to public use. Interest in the preservation of state. Third one, social interest. These are the claims or demands in terms of social life, which means to fulfill all the needs of the society as a whole for the proper functioning and maintenance of it. It interests in the preservation of general peace, health, security of transactions, preserving social institutions like religion, politics, economics. According to Dean Raskopound and Sociological Schools of Jurisprudence, there are 5 general postulates. First one, men just be able to assume that others will commit no intentional aggression upon them. Next one, men must be able to assume that they may control for beneficial purposes what they have discovered and appropriated for their own use, what they have created by their own labor, and what they have acquired under the existing social and economic order. Next one, they must be able to assume that those with whom they deal in the general intercourse of society will act in good faith. Next one, they must be able to assume that those who are engaged in some course of conduct will act with due care and not to cause an unreasonable risk of injury on others. And the next one, they must be able to assume that others who maintain things likely to get out of hand or to escape and do damage will restrain or keep them within their proper bounds. In this way, these are some juristic postulates according to the Sociological Schools of Jurisprudence. Next, Leon Digwit. Leon Digwit is one of the most important exponents and jurist of Sociological Schools of Jurisprudence. Leon Digwit was a French jurist and a leading scholar of droit public, that is public law. He was greatly influenced by the Auguste Comte and Durkheim. He gave the theory of social solidarity. which explains the social cooperations between individuals for their needs and existence. Now, what is social solidarity? According to Leon Dewey, social solidarity is the feeling of oneness. The term social solidarity represents the strength, cohesiveness, collective consciousness, and ability of the society. Leon Dewey's social solidarity explains the interdependence of man on his other fellow man. No one can survive without the depending on other men. Hence, the social interdependence and cooperations are very important for human existence. The objective of the laws is to promote social solidarity between individuals. And Leon Dewey considered that law as a bad law which does not promote social solidarity. Further, he also said that every man had the right and a duty to promote social solidarity. For example, in India, the codified laws are followed by everyone. Sociological schools of law studies sociology from the legal points of view. In India, sociological schools of law is a recent field of inquiry. Indian advocates of sociological jurisprudence are like P.B. Gajendra Gadkar, Upendra Bakshi, etc. We have the views of society from the legal point of view. The sociological schools of law is the interdisciplinary approach or subdiscipline of sociology. It views the society from the legal side and explains the interdependence of society and law. Sociological law explains the interdependence of law and society. So, there are some chief characteristics of sociological schools of law, and we can conclude on the basis of the above study of different jurists that sociological schools of law aims at the grasping law in its working. Next one, it is to provide expert advice for social engineering. Next one, the sociological schools of law makes an attempt to shape its studies so as to make them useful for practical applications. Next one, the sociological schools of law struggles with reality. Thus, the sociological schools of law aims at the understanding of legal and social phenomena, whereas the main concerns of the traditional approach to jurisprudence is to undertaking analytical linguistic studies. This is the introductions to sociological schools of jurisprudence. Thank you. Thank you, everyone.